Well, once a father establishes paternity, what are his rights? For the answer to that question and more, we turn to Live at 5's family attorney, Sonia Kaufman. So as far as a father's rights, what are they?
Well, if a father does not have paternity established, that's the first thing that he needs to do in order to get rights.
And that's just a simple paternity test.
Well, that's one way to establish the answer to that, but not to establish the legal rights. He either needs to file what is called an acknowledgement of paternity with the Bureau of Vital Statistics in Austin, or he needs to have a court's determination of his paternity in order to establish those legal rights. And once those rights are established, then usually there's a court order that sets those out, enabling him to visitation and the other things that go along with being a parent.
But it could also talk about child support as well.
Yes, it will.
So it may end up costing him a little bit. They are his kids, so that's all right. We'll go to our KFDM News Facebook page where we posted that you were on today, and it says, when I divorced my daughter's mother almost 10 years ago, the decree states that she pays no child support. Can this be changed easily?
I don't know about easily, but
it can be changed.
Yes. I would suggest to this viewer that he contact the Attorney General's office wherever he lives, Beaumont, Mid-County, in Hardin County, wherever he lives, and ask for an appointment to come in and have them review the decree and review that situation, and they can help him with that free of charge.
Okay, another question from Linda. As a grandparent, what rights do we have if we're not able to see our grandbaby? Can we take them to court to get grandparent rights?
That is a very complicated question, but every year that our legislature meets, they take away more and more of the grandparent rights. And by and large, there really aren't many grandparent rights in Texas unless the grandparent can prove that the child would be substantially harmed if they were not allowed access to the child. And it's all based on a fundamental liberty interest that a fit parent has to make decisions concerning their child, including whoever gets to visit with them. So it's very tough to do, but on a case-by-case basis, sometimes it can be established.
Okay, back to our KFDM News Facebook page. Brandy wants to know, my fiance and I had our income taxes done together for the first time in 2008. And the lady that prepared it for us did it as married, filing jointly. Does that mean by law, if we were to split up, we'd have to file for divorce even though we've never been married?
It could very well be. And I think what the heart of that question is have these people established an informal or common law marriage in Texas? And they may very well have. There are just 3 simple requirements for that, one of which is an agreement to be married. So by filing a joint tax return that says that they're married, an agreement could certainly be inferred from that. The second is that they live together as husband and wife in the state of Texas. Sounds like they have. And the third one is that they hold out or represent to other people that they are husband and wife, which they have by filing this tax return. So there's a pretty good bet that they are married informally, and that's just as legal as a marriage, so it can only be dissolved by divorce. There's no informal divorce. They've got to go to court and get a divorce.
All right, Sonia, thanks so much. We always appreciate you taking time to stop by. And if you have a question about family law, let attorney Sonia Kaufman answer your questions. You can fax us those questions at 892-7305, email them to laf@kfdm.com, or just watch for them to show up on our KFDM News Facebook page.